Hello everyone. Good evening, good day. We are happy to have you here with us through SCHNEIDER Group. My name is Elena Trankina. I am the head of import department at SCHNEIDER Group, and today we will be happy to share with you some of our knowledge about the current state of the unification and further development of the customs regulation in the Eurasian Economic Union and specifically in Russia. Since we are located in Russia, the focus a little bit will be more on Russia than any other member state. So the first slide will show us our agenda. So what we will be talking about today. First will be novelties in the customs legislation. We will specifically talk about the new customs code of the Eurasian Economic Union to come into force very soon. We will talk a little bit more about conformity documents. We have a lot of requests here at SCHNEIDER Group regarding the conformity documents, so that's why we'll be talking a little bit more specifically about them. Also, we'll talk about labeling of the goods, and we'll talk about authorized economic operator as one of the possibilities to make an easy entry to the Russian Federation. So, which are the main novelties in customs regulation? So, as I've been talking already, a new customs code of the Eurasian Economic Union will come into force on the 1st of January of 2018. So, for that customs code to be active, more than 30 decisions of the Eurasian Economic Commission have been prepared. They've been actively discussed by the business community, and some of them have been modified, and they will come into force together with the customs code. Also, at the moment, new technical regulations are being introduced. Old ones which already exist have been modified, and they are being more unified at the moment. And together with that, a new federal law of Russian Federation on customs regulation will also come into force. This law is now under active discussion. Different proposals have been made by the business community, so it will also come into force, as I said, together with the customs code. So, just to remind you about the Eurasian Economic Union. Starting from the 1st of January 2015, Customs Union was transferred into Eurasian Economic Union, and at the moment there are 5 member states of that union: Russian Federation, Republic of Belarus, and Republic of Kazakhstan, and Republic of Armenia and Kyrgyz Republic have been added to that union in 2015. So, what are exactly going now with customs code? So, as I said already, customs code will come into force after the process of ratification of the parliaments of each member state on the 1st of January 2018. New customs code consists of 9 parts. It contains 60 chapters. And this customs code, the authorities have been compiling it, are very proud of it. So they say that most new achievements of the worldwide customs regulation have been introduced in that customs code. They set this customs code set the priority of digital technologies. So it's electronic customs clearance, electronic customs declaration. It also says a one-window approach. What does that mean? It means that if a document have been once submitted to any authority by the company, there is no need to submit them further. Those documents could be obtained by the customs through their internal work with other authorities of the state. Also, a new approach, an automatic registration and automatic release of customs declarations will be introduced. What does that mean? It means that if the customs declaration is filed properly, all the fields are filled properly, and a company is in a low risk category. About that we will talk a little bit later. Customs declaration will be registered automatically without the customs inspector revising it, and if everything is okay, it will be also released automatically without the supervision of any customs inspector. And other very important thing is that there is no need to present confirming documents that have been mentioned in the customs declarations. What does that mean? It means that if you have mentioned something, for example, it works already now, but it will be broadened, this approach. If you have just mentioned, for example, a declaration of conformity in the declaration, you don't need to formalize the document and to attach it to the customs declaration. Those these data could be checked by customs authorities in the appropriate registry. So here are presented some novelties more specifically. So as you may see, there are quite a lot of them. There is a second page also. First one is that oral explanations are taken into consideration. It could not be considered that important, but you should understand that at the moment, only written explanations are taken into consideration by customs. But in the future, after the customs code will come into force, customs authorities will take oral explanation also. What does that mean? It means that you should be very careful while talking with customs authorities, because all your explanations could be submitted to the case if something is going wrong, and could be considered. So the second very important part is that the normative time for customs declaration release is decreased to 4 hours. At the moment the time is 1 day. It really doesn't mean that all the declarations will be custom cleared in 4 hours, because there are some tricky things in the customs code that if the customs have requested additional documents, this time expire and the new 4 hours are starting to count. But still, it's a very good achievement of the customs authorities, and they have right to fulfill those obligations. And normally at the moment, if everything is okay, we here at Schneider Group have also that examples that customs declarations are being cleared in 1 or 2 or 3 hours. So it's a very good improvement. Third novelty is that temporary storage time is increased to 4 months. At the moment, we also can enjoy a 4-month temporary storage, but they are divided in 2 and 2 months. So first you have 2 months, and only if if that time expires and you apply to customs authorities, they can prolong that time, but they cannot. By the new customs code, you will have the possibility to storage goods temporarily up to 4 months at the beginning. So a definition in the customs code, there is a definition of a mutually dependent persons. It's very important for the companies who have subsidiaries or branches here. So this issue should be considered. Other very important thing is that customs code introduced a possibility to apply for preliminary decisions on customs value and on the methods of calculating that customs value. That really doesn't mean that you will have a thorough analysis from the customs, because they are quite careful in their definitions, but still it's quite a solution for a company who is just entering Russian market, so they would understand on what grounds they are at the moment and how the customs value will be considered by customs authorities. As I already said, another novelty is that you don't need to have to present documents mentioned in the customs declarations to formalize them and attach to customs declaration. That really doesn't mean that you don't have to have them. At request of customs authorities, you will have to present them. But while watching customs declaration, there is no need to present them. Another novelty, as already mentioned, and it's a crucial one, is automatic registration and release of customs declaration. Also, authorized economic operator status is upgraded significantly, and we'll talk about that a little bit later, because it's very important improvement in our customs regulation. There is a slight change in subsidiary and branch status. So, by the current customs code and current federal law customs regulation, a branch can custom clear goods for personal needs. By the draft of the new customs federal law and customs regulation, there is no such possibility. So the authorities have not foreseen that possibility, and the business community at the moment are in the discussion with the authorities on that point, and we really think that it should be considered and it should be added on the federal law. But at the moment, this possibility is not quite sure. Another novelty is a declarant is responsible for the definition of the customs tariff customs code. So not everyone know, but right now customs and customs inspector personally is responsible for the definition of the customs tariff. So if, for example, a company who is launching customs declaration, an importer, have chosen the wrong customs code, there is no offense in that, and customs can just check that customs tariff and change it. By the new customs code, it will be, the declarant will be liable for that with all the possible offenses that are coming from that decision. And should mention that new customs code still have the principle of residency. What does that mean? It means that only a legal entity which is registered in the member state can apply customs declarations only in that member state. For example, a Russian legal entity cannot perform customs clearance in Kazakhstan or Belarus. And this principle remains in the new customs code. But a legal entity can choose freely a place of customs clearance within the country of residency. So even if you reside in Moscow, you can apply for customs clearance, for example, in Vladivostok or St. Petersburg or any other customs point which you find appropriate. So there is a new provision in the customs code for individuals. Also, customs authorities say that in a year after the customs code will come into force, the normatives, the amount of goods which could be imported by an individual from the electronic trade will be decreased significantly. First, it will be decreased to 500 euros, and then in consecutive years up to 200 euros. So in our opinion, it opens quite huge possibilities for e-commerce growth here in Russia, and at the moment huge discussions are going on that also. So we will talk about a little bit what else new is in the customs regulation. So Union is also actively working in creating unified markets. As any or many of you may know, on the 6th of May of this year, unified market of medicine came into force. What does that mean? It means that national medicine markets of the member states, they start to operate in a single space. manufacturers can apply for the registration certificates on their release under the common procedures. I should mention that the registry is not still working very well, and to apply right now at the moment under the rules of the common market it will be a little bit difficult, but we think that in some months the situation will clear out, and it will be a really good help to all the importers and all the manufacturers, because those registrations will be valid in all the member states. The crucial trend of further reforms in the Union, the Eurasian Economic Union, is ongoing implementation of electronic document flow in cross-border trade. So, as you may know, at the moment, since 2013, it is obligatory to present customs declaration, import customs declaration in the electronic form. So only, I guess, customs declarations of individuals could be submitted in written form. At the moment, customs also carry out an experiment on electronic custom clearance of transit declarations, and they are planning to expand that procedures to other fields of customs clearance. So, for your understanding, at the moment, 99.98% of the import customs declarations are submitted electronically. As already said, it is very important, and it is an ongoing trend, and automatic registration and automatic release of customs declarations. But customs specifically stress out that only companies with a low risk will enjoy that possibilities. Also, customs wants to trace the product from the beginning, from the day they enter the border of the Eurasian Economic Union until the day they end up in the hands of the final consumer. And for that, they are implementing different measures. We'll talk about them a little bit later. Customs is constantly switching the control measures to post control. It means that the thorough control at border is going mostly remains in the past, and customs implementing a risk profiling and customs inspection, non-physical customs inspection, they are trying to be more focused on the companies which are more likely to make offenses in the field of customs declaration, and to let the companies which are enjoying the status of companies with good faith to be to go easy on them. So, technical. We'll talk a little bit about technical regulations. We'll do it a little bit in questions and answer form. So here you may find an example of two most common technical regulation documents which are issued under the technical regulations. So what is technical regulations of the Eurasian Economic Union? So technical regulations of the Eurasian Economic Union are called to ensure the safety of goods which are circulating in our unified market. So they are set by Eurasian Economic Commission. At the moment there are about 34 active technical regulations, and about 21 is on the way. Those technical regulations, they are detailing the obligatory conditions to which specified goods and services are subject to in accordance with the unified list of goods. So there is another question: does every product needs a certification? Not all the types of products need to be certified. To clarify whether it products need to be certified or not, we normally need to determine the customs tariff for the product and the field of use. So goods which are subject to technical regulations, conformity documents should be issued. Normally, for the conformity documents to be issued, we need to perform some tests, and we here at Schneider Group strongly suggest to perform actually that test, because at the moment, if some problems are at the border with customs authorities, they sometimes even require to present that testing protocols to ensure that the goods are properly certified. And this also enables you to be sure that the goods have undergone the appropriate procedure and they are rightfully admitted into the unified market. So, is there any document that proves that no certificate is required for the goods? Normally, customs authorities does not require, but if sometimes there are some goods which have some issues, if you want to be just on the safe side, you can apply for we call it refusal letter from the authorities, which states that your goods are not subject to any technical regulation. So who can apply for the conformity documents? Could it be, for example, a German company or a company from Austria or from USA? An applicant for the conformity document issued in accordance with the technical regulation could be only the legal entity registered in the member state of the Eurasian Economic Union. So your producer can entitle some authorized representative here with a Russian legal entity if he applies for the conformity documents in Russia, or, for example, a Kazakhstan legal entity if he applies for conformity documents in Kazakhstan to represent his rights. So an applicant is legally is liable by law to confirm that goods are in compliance with the regulation. Here we come to that question: what are the most common conformity documents in the Eurasian Economic Union? Most common conformity documents are Declaration of Conformity, it's on the left, and a Certificate of Conformity, it's on the right. What is the main difference between them, and how should we define which exactly document should be issued? It is defined in every technical regulation specifically. So there is a list of products there which are subject to the Declaration of Conformity issuance, and there is a list of products which are subject to Certificate of Conformity to be issued. Declaration of Conformity is the the producer or manufacturer states that the product is in compliance with the technical regulation. Certificate of Conformity states in that document not only the producer but the certification authorities also states that the goods are in compliance with the technical regulation. That is the main difference between them. What is a state registration certificate? There are sometimes a lot of questions about that. State registration is another document. It have no connection with the technical regulation, and it confirms the compliance of the goods with the sanitary and hygienic standards of the Eurasian Economic Union. So an applicant for that document could be any company with no respect to its residency. So the applicant for a state registration certificate could be either a German, a USA, Austrian, or any Russian illegal entity, any other company who wants to apply for that document. Sometimes we need to issue a FASB notification. What is that? It's another quite common document to be issued here. It's a letter issued by the Russian Federal Security Service, and it is required for goods which contains cryptographic modules. For example, devices with the Wi-Fi modules, with the Bluetooth modules are subject to that regulation. A letter is issued only on specific models, so you cannot. So if you want to have a full range of your products to be circulating on our Eurasian economic market, you should specify the exact models you want to import in that letter. For that document, an applicant could also be any company with no respect to its residency. Another very important point is a question about the EAC marketing. What is EAC? What is that? EAC is some kind of a Eurasian conformity mark, and it should be applied to an individual product unit. Does every product need to have an EAC mark? No. That mark should have only the product that is subject to technical regulation. But once the product is subject to that technical regulation, it should have that mark to the goods to be entered for free circulation within the Eurasian Economic Union. If we do not mark the goods with that product, what could happen? The goods cannot circulate within the territory of Eurasian Economic Union. There is an administrative offense under the Clause 6 in Russia, for example, 16.2 Part 3, and quite huge penalties for that. It's about up to $5,000, and goods could be even confiscated in customs. So Russia have a very strong position in that issue, and if, for example, other member states such as Belarus or Kazakhstan, they permit the goods to be custom cleared without that mark, Russia does not offer that opportunity to the importers, and they customs authorities specifically say that goods should be marked with an EAC mark prior to lodging the customs declaration. So it's very important because the custom clearance could be denied if the customs will find out that the goods are not marked. How can we mark the goods? So there are three most common ways. Prior at the manufacturer's premises, of course, for all the importers is the most interesting way because it doesn't imply for them any additional costs. The other way is to mark the goods in some independent warehouse before entering the border of the Eurasian Economic Union. Some additional costs will happen, but still they are not that big. And the other opportunity is to mark on the bonded warehouses here at the customs border. It's the last opportunity we would consider because it's very expensive. The warehouses are not equipped quite properly for that, and it causes huge delays in customs clearance and huge additional expenses. What other information should contain the product which is being imported into Russia? It should state, the label should state the manufacturer, short description, composition, if it's applicable for that product, a model, trademark, and country of origin. It's specifically important for the products under the technical regulation, because the customs they check the compliance of the especially here in Russia, the compliance of all three components like conformity documents, EAC marking, and labels on the packaging in Russian. They should be presented in Russian and in the language of the other member states to which the goods are being imported. And the customs check all those 3 points with the description in the customs declaration. So they should all be compliant, and it's really very important. Here we have some examples of the conformity document issued for different products. For example, clothes for children under 3 years old. It's like for pajamas for boys. It requires state registration. It requires a certificate of conformity under one technical regulation with one test protocol. For example, the other product is digital camera with a Wi-Fi module. For that product, we will need FSB notification due to it contains Wi-Fi module. It is subject to 2 technical regulations, and for that technical regulation, we will need to perform 3 test protocols. So that's some small examples. And now we will talk about labeling. It's another labeling. It is introduced by the Russian authorities. It was last year. There was an experiment here in Russia, which was considered very, very good one. I'm talking like Donald Trump already. So it have permitted to increase the official turnover of fur products up to 400%. At the moment, for example, final consumers can check on the website of tax authorities whether the goods have been imported properly or not. In the beginning of this year, Russian ministry have signed also a decree that all pharmaceutical products should also be marked with that identification marks or labels. And at the moment, just a moment. And at the moment, there is a draft of the federal law introduced by Russian Federation on the marking of some other goods, and among them are mentioned perfumes, tires, cameras, some kind of clothes, and some kind of footwear. So, as I said, customs is trying, our government is trying to trace the products from the entering to the customs, from the customs border to the final consumer, and that is one of the measures to ensure that. So, authorized economic operator. What is that exactly? Authorized economic operator is a program that offers simplification of customs declaration procedure and significantly accelerates the release of goods. Russian customs authorities consider it a new model of a partnership between the customs and a business, and this partnership allow each of them have its own advantages and benefit from that partnership. In Russia, the application for the authorized economic operator status actually began only in 2012. On July of 2014, there were only 125 Russian companies. For example, in Europe, there are about 17,000 of authorized economic operators. In USA, about 11,000. So we are just only in the beginning. By the new customs code, as I already said, the regulation of the status of the authorized economic operator is delegated to a supranational level. So all the issues are delegated to not to national regulation, but to the regulation of the Eurasian Economic Commission. So the procedure of including into register is simplified. So what are the main who can be the authorized economic operator? It should be a legal entity registered in the Union. It could be either importer, exporter, customs broker, producer, bonded warehouse, or normally those are those entities. And the condition is that they should be included in the register of the authorized economic operators. How you could get into that registry? The procedure of including is very simplified. The application should be filed to customs authorities. They check the documents in 5 days, reply to you whether they are okay or not. After that, they have 120 days for checking thoroughly the documents. They check the premises and other things they consider relevant. And if everything is okay, the certificate is lodged into the registry in 10 days after it have been approved, or after the decision was made. One of the important provisions of the conditions for admission to the registry is a provision of a security deposit for customs payment. Currently it will be 50,000 euros for manufacturers and 1 million euros for importers. The novelty, very important one, is that the new customs code provides the opportunity to decrease that amount of the deposit. For example, if the status of the operator was not postponed during the 6 consecutive years, the deposit sum could be, at the end of the 6 years and the year 7, could be lowered to 150,000 euros. It is very important that the new customs code states that the certificate could be postponed up to 120 days. That really doesn't mean that if there is some breach, and your certificate will be postponed for that period. No, if you have eliminated the breach, for example, in 5 days, then the status will be renewed. What is the result, and what does the company get from that status? Normally, there are, at the moment, we have only one type of a certificate, and it offers not a very big number of simplifications. By the new customs code, there are 3 types of certificates, and the amount of deposit which I've been talking about refers only to the first type of the certificate. Type 2 and Type 3 doesn't require any security deposit, but if you want to obtain for example, the certificate number 3, you should have, prior to that, enjoy a status of the authorized economic operator, or the Type 1 or Type 2 for 2 years at least. There is also a provision in the new customs code that you should have a foreign trade for 3 years, consecutive years. For example, by the current customs code, you need to perform a foreign trade only for 1 year. So, what are main simplifications? For example, the certificate first level and second level, they enjoy each about 9 or 10 simplifications. The third type of certificate offer 17 simplifications. They are quite different, but main ones are listed on that table here. So it's release of goods prior to lodging the customs declaration, as precision and completion of goods on its own premises. It's exemption from standard risk profile, because the economic operators which are holding the certificate 2 and 3 are considered to be companies with a low risk, from a low risk category, and the standard customs formalities are not, customs formalities such as customs inspection are not performed on them. And even if they are performed on them, they have a priority in any customs formalities, additional customs formalities. Also, by the new customs code, there is a possibility, and our authorities are negotiating at the moment, that by the new customs code, this status is valid in all the member states of the Eurasian Economic Union, not only in the one which have obtained that status. For example, by the current customs code, it is only valid in the state which you have obtained. For example, if you are a Russian legal entity and you have applied for the status in Russia, it will be valid only in Russia. Starting from 2018, if you will apply for a status of authorized economic operator, it will be valid in all the member states. As I said, there are some improvements. Type of certificates, financial deposit could be decreased. For the financial stability and security requirements, they are relevant to the companies which are applying to the second and third type of a certificate, because, as I said, they don't have to have a security deposit. So the time needed for the release of goods have been specified and shortened, and the list of documents have been also shortened, and the procedure is more clear at the moment. And as I said, the authorized economic operator, they have a possibility to release the goods before final declaration and without a security deposit. For example, for other companies, the new custom codes provide an opportunity to file to release the goods prior to launching the customs declaration, but they need to have a security deposit. For authorized economic operators, this provision is not valid, and it's a very good improvement in their status. So, there is a procedure of a standard risk profiling, and Customs is actively implementing it at the moment. What does it mean? Customs calls it risk management, but actually it's a risk profiling. So Customs is defining importers into three categories: low risk, medium risk, and high risk. How they define, what are the criteria? They are quite uncertain, but the main ones about which Customs talks clearly is that the company should have no liabilities before Customs and federal tax services. They should have no anti-logistics, for example. It means that the company, these logistics routes should be economically reasonable, and Customs are obtaining the information for its risk profiling from the different federal authorities, from business communities. They have its own algorithm for that, and it's being improved significantly for years. What is bad in that risk profiling? The main thing is that currently importers in most cases are not aware in which category they fall in. So they could tell it only by the amount of control measures that are being performed on them. So if the number of customs inspections have been increased, that means that something have happened, but they don't have any possibility to know that for sure. So at the moment, business community is in discussion with customs authorities about that, and most probably it will be those the company will know in which category it is through its personal cabinet, as we call it, as the Russian customs call it, on its customs website. So, and to resume, so customs regulations of the Eurasian Economic Union is forced to meet with the requirements of the worldwide globalization. So new methods of customs control, such as electronic customs declarations, non-physical control measures, are implemented. So the control measures are switched to post control. Still, there are some improvements. There is still some room for improvements to be made. For example, as many of you know, maybe that currently here in Russia we have problems that Russian customs haven't admitted the certificates and declarations of conformity which have been issued by other member states of the Eurasian Economic Union. And though the business community have been in discussion with the Eurasian Economic Commission, and they have made its own decision that it contradicts the Eurasian rules, and even in ministry there was a provision that those documents should be admitted. Still, customs is not every customs point admits that declarations and certificates. They are requesting additional docs. For example, they said it's testing protocols, it's a service agreement with the testing laboratory, and so on and so on. And even, for example, customs declarations on the samples which have been imported into Russia or into other member state for testing. So, of course, not every company have it, and it's not legally requested, but still they are. Of course, there are, for example, different approaches of member states for direct deliveries. It's a very it's direct delivery from the third countries under the contracts between legal entities registered in the Eurasian Economic Union. What does that mean? For example, custom authorities refuse to, in customs clearance of goods which have been delivered directly, for example, from Germany under the contract which they have signed with the Russian legal entity. For example, here in Russia we don't have that problem. Specifically in Belarus they don't have that problem, and that problem was issued on a very high level by the President decree. But still, though we all are in the same Eurasian Economic Union, the rules are a little bit different, and they are considered to be different in the future. But another well-known problem is that customs authorities of Russian Federation, as I said, they require to mark the EAC mark on the labels prior to lodging of customs declarations. Kazakhstan and Belarus doesn't have that provisions, so the goods could be customs cleared without that marking, and that marking could be made later before the goods are sold to the final consumer. What are possible solutions? So we are just starting our way on that unification process, and one of the best and possible solutions is to actively, for a business community, to be proactive and communicate with the authorities and deliver its view on the current state. So our opinion would be considered, and the situation will be improved. Thank you for your time. So I hope everything was okay. So if you will need presentation, you should okay. So we have questions. Just let me read it, and I will. So we have a question here. Could you please explain when a technical regulation as certificate is needed and when a declaration is sufficient? You mentioned different lists. Where do I find this list? How do I know which kind of technical regulation is requested? So as I said, first we should determine the customs code. So after we have determined the customs code, we can identify whether the goods are subject to technical regulation or not, and we look specifically into that technical regulation. And in this regulation there are lists of products, and there are procedures how to apply for this or that document. And in that technical regulation there are lists, as I said, which specify which products are subject only to declaration of conformity and which products are subject to certificate of conformity. So you should, your steps are to define the customs code, then to search the appropriate technical regulation, and to look in that technical regulation what kind of documents would you require. So I'm not have a very clear vision. So We have a question about Unified Medicine Market, the Eurasian Economic Union that it came into force in May. What does it mean practically? As I already said, practically it means that the market is unified, and if, for example, at the moment you should apply for medical registration in each member state and it is valid only in that member state, in the future, if you will apply under the rules of the Eurasian Economic Union, this state registration for medical goods will be valid in every member state. And we have a provision that the certificate registrations which are already issued will be valid until 2021, but they will be valid only in the member state under which rules it have been issued. And another question: what will be the new duty-free threshold for goods purchased in the foreign e-commerce stores? Currently it is limited to $1,000 per person per month. Will they decrease this? Yes, as I said, there is a provision in the Customs Code that a year after it come into force, so we expect that the Customs Code will come into force on the 1st of January 2018. So on the 1st of January 2019, the amount of goods to be delivered by person should be decreased by to 500 euros. Actually, it's not dollars, it's euros. And there are provision for further decreasing of that amount to 200 euros. Also, authorities, especially here in Russia, are considering some other taxes, for example, a VAT tax or something like that. They are not quite clear what exactly they should do, but they see and they consider that deliveries that they are not compliant with their strategy, and so they really will implement some kind of that restrictions for free deliveries. Will VAT for foreign e-commerce stores be introduced? You know that starting from this year, a VAT was introduced, for example, for companies which are rendering digital services. That's kind. If you have a Google Drive, as I have it, from this year, I'm paying 18% more, and our authorities are on the way to introduce more taxes. I'm not quite sure about the e-commerce, but it is likely, in my opinion. Does EAC mark has to be applied to outdoor transport packaging as well, if it is already on a product label? Normally it is an individual label, and in our opinion it should be applied to an individual product only. No need to apply it to the outdoor product. So it should be applied to the unit which you will be selling. For example, if you are selling spices which are packed in a box and there is no division in there, for example, it should be applied on the box. If you are selling, for example, what else? Camera, you should be applied on the packaging of camera. Which document states that the new limit is 500 euros from January 1st, 2019. As I said, new customs code will come into force together with, and its implementation will be ensured by the decisions of the Eurasian Economic Commissions, and one of the decision is referred to that amount of the personal goods to be delivered freely into the territory of Eurasian Economic Union. So mostly in the decisions of the Commission. So that's it. I thank you very much for your time. I hope you have enjoyed and it was useful for you, and we are happy to see you in our further webinars. Thank you. Bye bye.